Good morning. The importance of advocates depends upon their way of thinking, their knowledge, up to date knowledge, their vast knowledge in other acts, corresponding rules, regulations. Therefore, at the time of drafting civil suit 138, domestic violence, whatever it may be, you should be very careful about the document which you are referring. See, the Registration Act and the Indian Stamp Act bars certain documents which you cannot mark, which that title. And you can also understand that you can object to the marking of those documents. Even though the nomenclature of that document declares some title, but the contents of the document may differ, and that title of the document may come under some other category for which stamp duty is more than the title which the document bears. For all these things, you can, if suppose your document is required to be compulsorily registered and you have not, the document was not registered, then at the time of referring the document, you must say that this document dated so and so is only for to prove the acknowledgement of debt and whatever may be about the handing over the possession, whatever may be favorable to. At the time of furnishing the details about document also, you cannot claim that the document is sale deed, partition deed, whatever it may be, family arrangement. You, instead of that, you can very well say that document document for possession, document for implementation of partition. Like that, you have to think variously. Here is a case, AR 2022 Karnataka 222. AR 2022 Karnataka 222 Veera Sangaya Gadigaya Mulimat versus Veera Pakshaya Iraya Gadachari case. Therein, the trial court impounded the document for being unstamped and unregistered. For that, the High Court, Dharwad bench of Karnataka held that you mark the document and then you decide the admissibility at the appropriate stage. This was the ratio they have given. Several judgments were referred, but they have followed AR 2015 SCW 6184. Therein, several judgments were discussed. You do not consider the judgment for one side. You can read the judgment and keep it in our file for your purpose to use either for the plaintiff or for the defendant. That much of abundant knowledge is discussed in the judgment. Particularly, they have discussed what is partition, what relate to family arrangement. All these things have been discussed. So therefore, it is very interesting what all are the provisions for compulsory registration and the Indian Evidence Act, about 91 Indian Evidence Act. All these things were discussed, and 14 of the Indian Registration Act. So many things, out document being impounded, also been discussed. Therefore, it will be a very good judgment for you. I understand you may follow what I said. Best wishes.